What's your badge number, by the way?
Matt Reardon. Mr. Reardon, I'm going to give you a warning one time only. The next time you call up here, the next time you give anybody in my staff a hard time, I'm going to have you arrested for contempt of court. You're not to come up here. When you call up here, you have to meet directly.
Your Honor, how did I do that?
Be quiet, sir. I understand you want to discuss something with me. Let's hear it. What do you want to discuss with me?
I was simply trying to inquire on the outcome of my ex. She falsely accused me of rape. You've created a monster.
Please take him on back. Take him on back to the back. Go to the back, sir. I'm going to hold you in contempt of court. Take him on back.
Your Honor, I was just trying to address this.
All right, sir, let's go. Come on. You want to go over your own?
Your Honor, please. My wife is outside. My wife is outside. My wife is outside. So which one?
I reviewed your motion to dismiss on the alternative transfer, but you are entitled to hear on that. I think just a couple of thoughts on it. This is your initial appearance, whether you plead guilty or not guilty, obviously, by looking at your motion or by viewing your motion in your dismissal of the alternative transfer that you are obviously pleading not guilty. So I don't know that I even need to ask you that, but I do want to rule on the motion. Anytime a motion is filed, a pretrial motion is filed, I always like to get those done in advance, because it's bad if you show up on the court, the actual day that you have the trial, and if those motions are denied or granted, then sometimes it's not even necessary to have a court date.
It's the story of my life. I've had 3 other courts that I haven't gotten any kind of rulings on my motions, and apparently, Your Honor, because I don't have a bar number, I don't get taken very seriously.
Well, I mean, it's again, you filed in the proper form. You did get it filed, and that's all you have to do here. You filed a written motion. I've reviewed all the allegations that you have. It kind of speaks for itself. It was a very lengthy motion, so I don't know if there's anything else you want to add to it. I would say that what I'm going to do is I'm going to deny your motion at this time, as I do all. It doesn't mean that it will be finally denied. You can certainly feel free, and you may know this already, to renew your motion once we have a hearing date on this, trial date. This is merely your initial appearance date. I'm going to deny your motion at this time for dismissal, and we're going to trial, and I'm going to give you a date. This is for a remote hearing, just like we're doing now. We're trying to keep everyone safe. You've got counter here. The other thing is I'm going to dismiss that. Obviously, you can renew that motion again on the trial date, and we're going to give you a Zoom trial date. We're trying to set these trial dates on a date that where you don't have to wait, as we did today for the middle of the date court date, and it's a date and time. So hold on just 1 second.
Okay. Your Honor, if I may, how can I ever get a fair trial without a jury in municipal court? It being the particular type of accusation.
Hold on just 1 second. January 14th at I'll do it at 1 o'clock. We're going to mail you continuous that. I didn't mean to interrupt you, Mr. Reardon. It's going to be January 14th at 1 o'clock. It'll be a Zoom hearing. We'll have they'll have the attorney here. I'll hear your argument. I'll look at your motion to dismiss again, and again, we'll take it from there. I know you're familiar with the court system. You said you've been in some other courts, so you kind of know how it works. I don't really have an answer for you if you feel like you're not getting a fair shake on it. But we don't have juries here. They have juries in justice court, but you're not entitled. No one's entitled to a jury.
Your Honor, that's why the whole in the alternative to transfer, I'm wanting to move this to circuit court in order to get a fair trial via a jury of my peers, and I find it highly prejudicial and even offensive, constitutionally offensive, to have to stand trial before my accuser as my jury.
I do take note of that point, and I did see that you had that motion to transfer in there as well. So I'm going to deny that motion to transfer. Again, I will transfer cases if the law says, if I believe that they need to be transferred, I can do that to justice court. But in this case, at this time, I'm not transferring it. And I will take note of your remarks. Again, you feel free to make the same arguments again if you need to, or if you feel like you want to. On this other day, you've always got whatever decision I make. If there's a fine, I'm guilty. Obviously, you always have the right to appeal my decision to the county court of DeSoto County, and then that you are entitled, according to the judge. You may be entitled rather to a 6-person jury to hear your arguments at that point, or to hear your case at that point. So
that's what
it'll be a Zoom court meeting.
Yeah, I'm going to go ahead and I'm going to go ahead and I'm going to appeal it though, because I feel like it's just dragging it out. It doesn't need to get drug out all this time, and I can't. Your Honor, you know as well as I do, I can't get a fair hearing in front of the accuser. That is presiding over the case.
Well, again, you can make those arguments, obviously, and if you whatever appeal steps you need to take, you can certainly do that. That's up to you. But as I said, I'm overruling your motion at this point, and I'm dismissing your counterclaim because of the lack of jurisdiction. And we'll send an order out to you, a formal order in writing. It tells exactly what I did, where you'll have it. And then again, you can take whatever steps that you feel like you need to between now and your next court date.
Okay, Your Honor. One other thing, I've asked on 3 separate occasions for a simple, complaint, criminal complaint or a civil complaint. I don't know if this is civil or criminal. I've yet to be served anything, and I've asked now on 3 separate occasions for a crime bill. Just simply a complaint to be sent to me to be able to read the affidavit, read the crime, and in all 3 they've been ignored.
Well, are you saying that you don't have a copy of the affidavit?
I don't have a copy of the affidavit, no.
Okay, we can get that to you. Your prosecutor, you've requested discovery. Of course, the rules state he's got 30 days to respond to you, but he's going to be doing that and responding to the discovery. He's the one handling your case, and I understand what you're stating, and I'll make a note here of your request again verbally, even though I think you've requested it before, you said. So we'll have a response to you certainly before the court date, and we will see you on that court date.
All right.
Thank you.
Thanks.
Mayor Phillips, Mr. Dye. As a prior resident of Olive Branch, and the love for Olive Branch that my small family did share, it pains me to be typing this letter to you. Yesterday, on the 19th, I dealt with the most abominable, putrid of dealings and treatment by your municipal judge, Leslie Shoemate. That in itself is an upgrade for the complete lawlessness, lack of moral turpitude and integrity, and sharp, hard turn away from the Constitution and expectations of a functioning society. This type of reprehensible behavior by any government employee should never be tolerated. Yet it's become a common reality that I've witnessed more and more over the past several years, and especially when I decided to embark on my inner calling to document and produce in the live, ongoing documentary series, Riding with the Outlaw. I am a Marine Corps veteran. I swore an oath to my country to uphold and defend its Constitution against all enemies, both foreign and domestic. And the clear, cutthroat attack by this lawless municipal court judge in Olive Branch today pretty much undercut everything that I've seen and documented. There's an extreme abuse and fissuring of the judicial gavel, a permanent staining of the robe in which he wears, most certainly a tipping of the judicial scales, and a sharp declaration of war on our blended constitutional republic / democracy. The founding fathers of America, who declared our independence, are rolling over and over in their graves. The same ones whom outlined and emboldened our basic human rights of life, liberty, and the pursuit of happiness, and composed our Constitution, which has been the foundation that has set and molded America as the last truly free nation in the world, governed by laws meant to extend to all individuals and especially to protect all, especially naturalized citizens. In my time of dedicating myself to my country, and in my 33 years, I know of one Constitution, one set of laws, not two. This judge is not above the law. He's not above the Constitution. And the treacherous mistake that he just made yesterday is definitely going to cost Olive Branch. Judge Shoemate is a danger and a liability to the city of Olive Branch. He is a tarnish on the good name. I trust to it that Mr. Mayor and Mr. Dye will see to it that Judge Shoemate is relieved of his duties as municipal court judge of Olive Branch by the end of the day tomorrow. Watch this video. See the proof. See that I did nothing to deserve the consequences that I reaped yesterday. All I've asked since the beginning were for equal protection of the laws, for the laws to be applied evenly. And I don't think I'm asking too much. My name is Matt Reardon, and I am the Oxford Outlaw.
This call may be monitored or recorded for quality assurance purposes.
Hello?
Hey.
say, I don't want to fight with you. You know, this is what I did, you know, out of, hey, let's just have some peace.
Well, and I mean,
I didn't tell you because it was one of those, you don't let the left hand know what the right hand is doing.
I understand, and you need to understand that if I wanted to fight, if I wanted hate, I mean, do you not think I had every opportunity under the sun? As long as
I'm pretty sure of that. I'm pretty sure of that, Matthew, and that is something that I also considered. I know that you can fight your own battles, and I know that you will.
I mean, that's why, despite through it all, I mean, I've been far from an unreasonable person, despite all the shit that I've had to deal with over the last 3 years.
I know that, Matt, and that makes two of us. But
Well, I think what I had to deal with was a little bit more serious.
Well, potato, potato, tomato, tomato.
No, it was a certain huge difference, because had the circumstances have been different, and had I been living in Oxford, I would have been guilty until proven innocent, and I probably would have been fucking shanked for the accusation that was put against me. Definitely the first one, and quite possibly the second.
Matt, again, there are things that you and I both have to take to the cross. And I know for a fact that there are things that I have definitely taken to the cross and have left there. And it is pure evil and hatred for me to be subjected to everything brought up over and over again.
I just never did confront it. You and I never did actually talk about that. I have no idea why that happened. I can only assume it was probably Dustin, and played a part in it.
That was a major part, yes. Again, there are things that we have to take to the cross, Matt, and leave it there. Matt, nobody is perfect.
Hey, Maddie's calling. Let me get this.
Okay.
All right.
All right.
Bye.
Hey, what do you think? Now I've got it on you. And what's your name? Amy? How old are you, Amy? 6. How many sisters do you have? You 2? Have you already forgotten Lydia? How long has it been since you've seen Lydia? You don't know? Hey, you seen her at school? Hey, baby, lay the other way. You don't want to. Hey, you never want to be laying with your legs spread towards anybody or on camera. You miss Lydia? What all did you and Lydia used to do together? Played. What was your funnest thing whenever she came over? And when y'all had the phone, make silly recordings? Yeah. Your mom Mom and I heard those. Those were pretty funny. I don't know if you knew, but y'all were recording little bits and pieces. There's Matt Reardon, Manic Mobile. Lydia's on the radio. Hopefully you get to see her tomorrow. I know all of y'all miss her tremendously.
Afternoon, U.S. Attorney's Office.
Yes, ma'am. I'm trying to figure out who I need to speak with. Who oversees y'all's department?
It's the Department of Justice, is that what you're asking?
Yes. Okay. Would I need to contact Jackson, or I'm trying to? I feel like y'all's main job is not being done at all. I mean, I'm a citizen of the state of Mississippi. I was framed in what I think is the largest public corruption scandal. It involves people in the local government in Oxford. I've been calling now for 2 weeks. I've been leaving messages. I got a call that I missed last Friday, and I left a message, a voicemail 2 days ago. I don't know what could be more important. Like, in 2 weeks' time, not getting one phone call. Go to the U.S. Attorney's Office, and something this big, somebody should have reached out to me by now.
Okay, one moment. I'm unable to assist you in this situation because I'm not exactly sure what's going on. But I'm going to transfer you to someone who can hopefully help you.
I hope I can speak to somebody finally.
This is Robin. Sorry I'm away from my phone right now. If you'd leave a message, I will call you back as soon as possible. Thank you.
Robin, this is Matt Reardon. I left you a message 2-3 days ago now. I've been calling up there for about the past 2 weeks in regards to what I think is quite likely one of the largest public corruption scandals in the state of Mississippi. And I can't even get the U.S. Attorney's Office to give me a call back. It's a damn shame. So clearly I'm probably just going to have to go this route on my own. I think that just not even getting a call back, the U.S. Attorney's Office is not interested in investigating this, much less hearing about it. So, if you're in the office today, please give me a call back, 662-892-0132. I got to be honest with you, it really, really bothers me because the agency's tasked with protecting the American people through not even responding, do not even help, are hurting the American citizens. And I'd like to think that that's not what's going on up there, but 2 weeks' time, and I've stressed the importance of this, my time is running out. The statute of limitations is running out. Please give me a call, 662-892-0132. Thank you.
Hey, you gotta move that.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more
I'm
time.
here at the sheriff's department.
Move. or you will go to jail for disorderly.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop! Ah! In the Justice Court of Lafayette County, Mississippi. Lafayette County, in the state of Mississippi, versus Matthew Reardon. This is the defendant's motion to dismiss or transfer in regards to disorderly conduct and resisting arrest. Comes now, Matthew Reardon, your defendant, and brings his motion for dismissal or in the alternative to transfer venue to an alternative jurisdiction outside of Lafayette County, Mississippi. Else defendant hereby gives notice of his intention to immediately petition the U.S. District Court for the Northern District of Mississippi for emergency injunctive relief and the determination of jurisdiction in this cause due to all reasons of prejudice and biasness, which the plaintiff in this matter is well aware of and shouldn't need to be reminded. Without waiving any of his rights, defendant Movant hereby enters his plea of not guilty and hereby gives his answer. 1. Movant asserts that this complaint stemmed from what easily appears to show that defendant was retaliated upon by Deputy Courtney Dixon, who knew and had issues with the defendant prior due to his filming of a documentary called Riding with the Outlaw in an effort to seek vindication and justice for the criminal acts aggrieved upon him. Deputy Dixon is seen during one of the defendant's more recent video releases, approximately 2 months prior, threatening defendant with arrest and further fishing for irrelevant information in order to try to arrest defendant for some reason or another. This all ends with Dixon asking another deputy if he would like to write up a report on the defendant simply for defendant being at Sheriff's Department conducting an independent investigation and trying to ascertain answers to a particular grievance as to why Major Alan Wilburn would not produce evidence to an untrue, libelous, and defaming statement he gave to the Oxford Eagle on May 30th, 2017. Regardless of the matter, defendant had every right to be at the Sheriff's Department and to ask questions. The plaintiff has absolutely no right to threaten or restrict the liberties of another over personal views, especially when that individual is trying to ascertain answers which are part of a currently ongoing litigation. This particular occurrence is shown in the release Patriotic Pushback, beginning right after the narrative on the homepage of MattReardon.com, and defendant will list that as Exhibit A. Number 2, that on December 27, 2020, defendant had emailed Sheriff Joey East in an effort to get the Sheriff of Lafayette County to enforce the laws evenly and equally, further extending to defendant, among others, the equal protections of the laws as guaranteed by the 14th Amendment to the United States Constitution and further guaranteed by Article 3, Sections 8, 11, 13, 24, 26A, and 32 of the Mississippi Bill of Rights, a major part of its Constitution, and the rights of all citizens. Defendant in this cause continued to be victimized by acts of criminal conspiracy and organized crime by way of his ex-girlfriend and mother of his child, Phyllis Liz Crowder, her attorneys, and certain other John and Jane Does. None of this mattered to this department, nor this county, as defendant in this cause was the victim. Defendant asserts due to ongoing litigation and the fact that Lafayette County amassed such massive liability on itself from 2 prior conspired upon false arrests on defendant, which defendant had gathered indisputable evidence on, it was not going to provide defendant with equal protections, and it in fact has been complicit in the ongoing criminality. Lafayette County Sheriff Joey East read but did not respond to the email of defendant's grievance in seeking assistance of law enforcement to deter such major issues stemming from the criminal conspiracy of his ex. Email attached as Exhibit B. 3. It was the following day, December 28, 2020, that defendant drove to Lafayette County Sheriff's Office to await the sheriff in order to confront him in person so as to attempt to compel the assistance of the sheriff, as it is the Lafayette County jurisdiction in which the major issue stems. Defendant parked next to Sheriff Joey East's vehicle and awaited the sheriff outside so he could obtain some type of answer from the sheriff. a publicly elected position in which providing answers should be an obligation that most certainly is backed by the protections of the defendant's First Amendment rights to petition the government for a redress of grievances. Soon after, Deputy Dixon came out with Deputy Omar Ahmed. Dixon told defendant to move his car, to which defendant replied he would happily do so once he spoke with the sheriff. At this point, it was clear the sheriff was intentionally avoiding him. The deputy then said defendant had to move it now or be arrested for disorderly conduct. Defendant simply tried to ask how awaiting the sheriff could be considered disorderly conduct while in the process of moving his car to another spot, when this off-tilt, completely perturbed sheriff deputy told defendant he was under arrest and proceeded to grabbing defendant and throwing him on the ground using extremely excessive force, clearly demonstrating his dislike of defendant and the way he used extremely excessive force in the way he made his arrest. In the process, defendant's head was struck against the ground, along with his cell phone being thrown. It is the impression of defendant that this was done in an effort to damage or destroy evidence, although defendant can't make such claim with 100% certainty without seeing the video recordings from the outdoor camera. By this time, the sheriff was outside, just watching like a spectator would watch a sports game. Defendant never resisted arrest, even though Mississippi is one of the few states that actually allows the resisting of an unlawful, undeserving, and unconstitutional arrest, which defendant states in assurance is exactly what this was. Defendant was then restrained for upwards of at least an hour in a restraint chair with his hands tied uncomfortably behind the chair while jailers and inmates watched. The sheriff still refused to talk to defendant about his grievances. 4. Defendant received a bond amount of $500 the next day. Defendant and his spouse arranged for bond to be paid, and upon the bonding agent and defendant's spouse arriving between the hours of 5 p.m. and 6 p.m., they were turned away after being told Lafayette County Sheriff Joey East was invoking some special authority to personally sign off on defendant's bond, and would do so the next day after he personally spoke with the defendant. The sheriff waited until the afternoon on the 30th of December before pulling the defendant into a room and discussing with him his tactics and assertiveness in a courtroom, and in the way he sought justice and vindication, classifying it as wrong when it was this very department, along with the malice acts of the district attorney's office, that outrageously destroyed the rights and life of defendant just 3 years prior. Once again used fear and arrest as a tactic in their arsenal to try to sway a favorable outcome. Defendant asserts this amounts to false arrest and unlawful detention, among others, wherefore all premises considered. Defendant requests this cause be immediately dismissed, or in the alternative to be transferred due to the grievances stated within. Otherwise, defendant counterclaims in the amount of $5 million in damages, thus making the jurisdiction
the Oxford Outlaw. I wanted to go ahead and I wanted to cap up what all just happened, what all just took place. Nothing really that big. In fact, I already put out an article about this. Had court at Justice Court in Lafayette County in front of the Honorable Mickey Avent, and I do truly mean that. He's one of the, I'll say he's probably the only straight judge that Lafayette County has when it comes to justice court. He's by the book. And that's the only reason why I decided I would go ahead and I would keep it in Lafayette County. I would fight it in Lafayette County. Judge Avent told me last week, he started reading my motion that I submitted. Hell, by now he's probably seen the video. He told me because he was the judge on the case and he saw that it started spilling into the details, he stopped reading it right there. So there was no, in advance dismissing. Lafayette County is in fact not dismissing the charges. So I am in fact I'm giving Mickey Avent the benefit of the doubt here. I'm gonna let him try it. because I think he can. Although I think that there are certainly a lot of conflicts of interest here in the area. I think that Mickey's going to look at the facts. And I think that regardless, I think that he would weigh it evenly. And I think regardless, he's going to come to the same opinion that I did. That in no way, shape, or form did anything that I did truly constitute an arrest by Courtney Dixon. Horrible state actor. Omar Ahmed, right there with him. Horrible. What was funny is, looking back at the police reports back from 2015, I was arrested for family disturbance by none other than Omar Ahmed and his partner, Courtney Dixon. Isn't it funny that they roll together even today? Joey East refused to speak to me. He watched like it was a spectator sport while they were trying to beat my ass in the parking lot. Well, I got news. $5 million counterclaim against Lafayette County. I'm getting it filed. Motion discovery and subpoena Deuces Tecum getting issued today. It's been a crazy last 6 months, technically about 9, since I came back here to Oxford to get to the bottom of everything. And since I got back, crazy is an understatement. By now, I think I've sent the message that I'm not scared and I'm not back down. I'm not going anywhere. See, I was talking about the other day, there's so many ironic similarities to 2017, everything that happened in 2017. If you really start piecing it together, everything, and I mean everything, lines up. Liz Crowder, unfairly, just out of the blue, 2017 kicked everything off when she took my daughter, kept her held hostage away from me. You have the sheriff's department that made a stupid arrest for disorderly conduct that really set everything in motion. You look at today, you had another stupid arrest by the sheriff's department for disorderly conduct. And they tagged resisting arrest in as a little added icing on the cake for them. They added in Olive Branch with a crooked judge over there when I was already victimized. But there's one thing different in 2020 and 2021. First being, I've spanned this thing out a lot longer. This is a quick, what they did 3 years ago was quickly thrown together without much preparation. What I'm doing now is 100% methodical. I'm premonition. I see what they're doing. I'm 3 moves ahead, but they weren't ready for me to take the battle straight to them. James O'Keefe just put out a message about exposing big tech. We can't forget to expose corrupt state actors, and that's what I'm doing. Check out MattReardon.com. In the Circuit Court of Lafayette County, Mississippi, Matthew Oliver Reardon versus State of Mississippi, cause number L20-316. This is a motion for relief from judgment or order. Comes now before the court, Matthew Reardon, the petitioner and plaintiff, and respectfully moves this court for relief from judgment. Cause number L20-316. Petitioner would show just cause through the upcoming reasons listed. Showing to the court the following reasons Movan is entitled to relief. Fraud committed on behalf of Lafayette County